typing is an essential after dictation. Try exam-oriented typing tests, check accuracy, number of errors, gain speed, and more. Complete the typing test in a given time. Read dictation materials. Subscribe to get contents via mail. Purchase shorthand journals and more.
The fact of the matter is over a criminal proceeding under Section 498A of the Indian Penal Code. Tripti Roy instituted the case being GR case number 143 of 2000 under Section 498A IPC of Montesquieu Police Station. After investigation of the case, the police submitted the final report in the said GR case. Being aggrieved and dissatisfied with the said final report submitted by the police, Tripti Roy submitted a Narazi petition, and on the basis of the petition, treating the same a petition of complaint, the learned SDJM Kalna Bardhaman took cognizance of the offence on 9/11/2000, and thereafter the learned magistrate transferred the case of the file to the learned JM Kalna. On 31/1/2001, the learned magistrate, after examining the complainant and one witness, found a prima facie case and issued summons against the petitioners under Section 498A of the IPC. A Narazi petition simply means a petition which disapproves of the final report submitted by the police after investigation. Here, in this case, investigation of the petitioner's complaint of mental and physical torture perpetrated against her by her husband and others. In this case, FIR was lodged by the complainant (start) Narazi petitioner Tripti Roy, wife of Partha Sharathi Roy, the revisional applicant number 4 close, on 16/4/2000, and the said complaint before the officer in charge Montesquieu PS had detailed a case of physical and mental torture punishable under Section 498A IPC. It had also spelled out that the complainant Tripti Roy was physically and mentally tortured over a dowry demand of rupees 20,000 over and above a dowry of rupees 50,000 in cash plus gold ornaments and furniture, which were already given at the time of marriage. The police submitted the final report, and SI S.K. Ghosh of Montesquieu PS, who investigated the case, said in his report that it was not a fact of torture upon the housewife, and accordingly submitted that final report. It may possibly be borne in mind that a Narazi or a protest petition is no complaint proper by itself, but is treated within emphasis mine as a complaint. The original complaint, along with the FIR made by the complainant Tripti Roy, was already there, detailing the story of physical and mental torture and making out a case under Section 498A IPC, for which the investigation had started. Cognizance was taken by the learned magistrate on the Narazi petition, which was treated as a complaint. Materials were already there before the learned magistrate to give application of his mind to the allegations made by the complainant Tripti Roy. The Narazi petition also specifically referred to the case in question being GR case number 143 of 2000, in which the final report was submitted and by which the wife was aggrieved, and which also she is approved and prayed for fresh investigation and penal action against the accused persons in that case in view of the allegations or complaint he made in connection with that case. So, the Narazi or protest petition could be treated as a complaint, and cognizance could be rightly taken on the Narazi petition, which was inextricably entwined with the complaint proper in the form of FIR in connection with the GR case number 143 of 2000, which was specifically referred to in the said Narazi petition itself, and in respect of which the final report was submitted, and which precisely were all before the learned magistrate to apply his mind on a complaint and his taking cognizance, and then for examination of the witnesses following the inquiry which he had rightly and which rightly resulted in the issuance of process against the accused persons under section 498A IPC. If you have liked the video, hit the like button and consider subscribing.